Audio check. How do you read?
Awesome, thanks.
All right.
Thank you, Kayla. Norman Thornton.
Willie Tony?
When was the last town meeting about? And it was about a regular council meeting.
Good evening and welcome to the meeting this evening. I'd like to start off with a roll call of the members of the BZA board. Mr. Norman Thornton,
Present.
Mr. Willie Tony,
Present.
Ms. Shakira Imba,
Present.
and Jim Turner. Okay, so we have all the members present for the meeting. The BZA minutes were sent out previously via email. Did everyone have a chance to review them?
I did.
Yes.
Okay, can I get a motion to approve it?
I have an objection, actually.
Okay,
I found that those minutes were very scant and did not emphasize enough what actually occurred at the meeting. And in future, that we have this recorded so that we have some accurate record to fall back upon.
okay. Good point. Any other objections? Okay. If I could get someone to second to move, we approve the minutes.
I approve them.
Okay. And second, somebody?
I'll second.
Okay. And I guess that means the minutes are approved. And thank you for the note about the being or having more information available. Okay, so this evening, we have an action item, and it's an application for appeal. Jeffrey E. Campbell and Scott H. Campbell, first successor trustees of the amended and restarted relocatable living trust of Herbert H. Campbell, dated September 4th, 2013. This is a public hearing. First of all, are the Jeffrey and Scott Campbell present? Okay, excellent. I'm going to turn it over to Mr. Cicero to.
Thank you so much.
You all would be able to adopt the agenda for tonight. That is another action that has to be taken before we start the public hearing.
Okay, so yes, this is yes.
I make a motion that we adopt the agenda as written.
Okay,
I second that.
second, okay. That sounds like it's been adopted for this evening.
Still got to vote.
Mr. Turner.
Do we need to
I
vote?
don't mean to interject, but if you can take a voice vote on the matter.
Take a voice vote,
Yes,
okay,
when you're.
very good. So, Nick, do you agree for the agenda?
I agree with the agenda.
Okay, Tony
Yes.
and Shakira?
I agree.
Okay, and I agree as well. Thank you. Okay, so it's adopted.
Thank you so much. Alrighty, Kayla, can you please put up the presentation if you would, please?
Very good. So, Nick, you
And then could you also turn off the sound on the live stream as well, please? Thank you.
There should be audio coming out of that, the video is off.
Sorry, everyone. Hello? Hello? Sorry, everyone. I heard it again. I'll be right back. Port Road, GPIN number 8289-11-4154. The appellants, as shown on the screen, are Jeffrey Campbell and Scott H. Campbell, the first successor trustees of the amended and restated revocable living trust of Herbert H. Campbell dated September 4th, 2013. Next slide, please. The appellants are requesting that the Board of Zoning Appeals hear and reverse the decision of the town staff dated August 2nd, 2021, regarding the denial of a certificate of occupancy request from a proposed tenant to occupy tenant space identified as 17956 Colonial Port Road, owned by the appellants. The appellants argue that the current use of the property is non-conforming. Next slide, please. And then here's some background on this appeal. It's shown on the slide here. Staff followed the procedure outlined in the zoning ordinance when reviewing the certificate of occupancy application. From the Department of Planning and Community Development, what we review for is the proposed use, the current use of the tenant space or property, along with determining if the property has enough parking or tenant space has enough parking, along with any signage, location of dumpster. Everything else regarding this would be reviewed by the Public Works Director. And just some background on this process. So we received this application on June 11th, 2021, which is Friday. We've reviewed and then provided comments on June 21st. And then following this, part of these comments, we asked for proof of nonconformity because of the current zoning of the property is for flex business office district, and the proposed use, which is a warehouse and an automotive repair shop. It's not a permitted use through conditional use permit, nor through it's not permitted by right nor through conditional use permit in the flex business office district. And therefore, the Department of Planning and Community Development denied the certificate of occupancy on August 2nd. A little bit more about that is for that CO process, the first review is done by the Department of Planning and Community Development because we do not want to burden the Public Works Department with completing their part of the procedure of the application before we give zoning approval. So once we determine that the proposed use is not allowed in that district, we provided our denial to the Public Works Director. And that's when I also provided, the Public Works Director also provided that denial to the applicant and the appellant as well. And then on August 16th, 2021, an appeal of staff's determination was filed by Jason E. Hickman of Compton Dueling LC on behalf of the appellants. Next slide, please. So regarding this, staff's position is that the appellants did not provide any valid COs or business licenses supporting its claim that there was a lawful non-conforming use located on the subject property within the last 2 years, which is from the zoning ordinance section, which was attached as a part of your staff report tonight as attachment 5. Along with this, the proposed automotive repair shop and warehouse uses are not permitted by right nor through CUP in the flex business office zoning district, which this property was rezoned to in 2003 by town council, and which it's currently zoned as we speak. Beyond that, for a non-conforming use, there are three precedents that have to be set that the use was continued, whether it be minimized in size or if it was lawfully continued over the years, which for the town of Dumfries, a lawful non-conforming use is one that has a business license and certificate of occupancy application on file. Also that the use is not continued for two years. During my research, I was not able to find anything that supported that there was an active business license or CO in the last 2 years there at that property, or specifically for this tenant space. And I would like to point out that is what we're discussing here tonight, the denial of the CO for this tenant space in particular, not for the property itself. And can you please go to the next slide, please? Here is an image of the current property, and the location of the proposed use is within that structure in the middle, where the orange arrow is pointing. It would be one of those suites located there. And can you please go to the next slide? So the summary and recommendation is that staff asked the BZA to affirm the decision dated August 2nd, 2021, denying a CO for the proposed automotive repair shop and warehouse used by the applicant in the FB- office in the flex business office zoning district on the grounds that such use is not a permitted use in that district, and the appellants have not established that they have a lawful non-conforming use. That is, and just to add on to that, in the matter before you tonight, the burden is on the appellant to provide information regarding the interpretation of staff being incorrect. And that is all I have for right now, and I'm open to answering any questions you all may have. Thank you.
for the 2008 from the BZA, your staff couldn't find it, and you could find no other way of receiving that information. Is that true?
Yes, that is true. I could not find the final decision of the BZA from 2008. What we have is the transcript from 2008 from the BZA appeal that was similar to this in March, I believe, of that year. And then it was appealed to the circuit court, and it was reversed and remanded to the BZA at that point, but a final decision was never made. Based off of my research on the matter, I went through archives, I went through our community development drive. I could not find anything in the file.
If such information could be located, what impact would it have on this case?
Regarding that, it would make this case a little more easier to understand. It would make the decision easier to understand. It would determine if what the final decision was in terms of, is it a non-conforming use, and the final decision of the BZA at that point. And it would, from a zoning perspective, it would make the CO application in terms of this. It would allow us to make an easier determination whether we could approve the zoning of the property. However, I have to add to the certificate of occupancy process, the public works director also has to review it. And if she inspects this, if she would have gone and inspected this, I can't speak to that final outcome then of that. Based off of this, it may have impacted the zoning approval. But beyond that, I can't speak to that.
Okay, the reason I asked this question is I happen to know the former chair of the BZA during that time. I think she was not the chair at the time, but she was a participant for a long time in the BZA. I also know her to be a person who keeps records, from long periods of time. So if she were to have such record, would it be admissible?
I would prefer the town attorney to speak to that.
If I might, Mr. Chairman, and then also I think the answer is that if she had any documents and they could be validated as town documents, they might be useful. I would have Mr. Cicero, however, explain to you that notwithstanding whatever was determined in 2008 by the BZA, it appears as, and correct me if I'm wrong, Nick, that no certificates of occupancy or business licenses have existed for this property for the last 2 years. So even if we got to 2008, 2 years back from 2021 would still make it problematic in terms of being a legal non-conforming use under the town's ordinances and state law. So correct me if I'm wrong on that, Nick, but I believe you advised me you did a search of that. And so again, I think it would be interesting to know, but it's certainly not dispositive of where we are.
It's not
right now.
dispositive. Okay. I will take a look and see if I can find any information to that, and you have to make the decision, I guess, about its impact.
Perfect. Are there any other questions regarding this?
In the light of full disclosure, for your information and for the information of all the folks in this room, I chaired that meeting that night. Mrs. Begley, she did not.
Okay.
So, and I do recall when I was reading these information, some of the discussions that we had, that was 13 years ago?
Yeah,
So
13 years ago.
didn't really want to try to relive all of that, but I do remember that there was a lot of, this room, we had about 50 people in this room that night. And her father, Mr. Irv Gamble, was well represented. I think he had about 4 or 5 lawyers with him. We had Mr. Bindall supporting us as the town attorney. And the discussion is centered around same thing. Someone had applied, I think it was they had submitted a notice of violations.
Yes, correct. I actually, sorry to interrupt you, Mr. Tony, but I actually had the transcript from that meeting in my office, and I didn't want to attach it to this staff report just because that was 13 years ago, and I didn't want to, it's the same sort of application and for appeal, but it's been 13 years, so I didn't want to put everyone through that.
I'm sitting here, the question was asked about previous chairman, so I thought in all candor, I should.
I appreciate that, though. Thank you.
Thank you.
And if there's a reason, I remember what transpired, some of it,
Yes.
I've been involved in quite a few hearings since that time, but, I do remember, and I do remember the decision that was, after we had adjudicated that we came to. There were quite a bit of, there were quite a few things came out during that meeting. Some of the tenants there did not have current business license or occupancy certificate.
Yeah.
Some of those folks lived there. But I don't think it's really relevant to this, although it's similar.
Yeah.
But this is a different thing. That's why I really didn't want to all go through all that.
Oh, 100%.
Be quiet. They
No.
just want to ask me some questions.
I appreciate that. I really do. And it's great to have the information, and we are glad to have someone like you on the BZA.
If I might share, I think it should be noted that Dumfries is a town that has their zoning, it's an inclusive town, some inclusive ordinance, wherein if it is not listed as a by right use in a particular zone, then it's not allowed.
Correct.
Unless you go through some processes like the CUP or the appealing or text amendment or something of that nature. So I sat on the planning commission for 7 years, and I sat on the BZA for 8 years. So I think I do have a little background in terms of understanding what this process is about.
Yep.
And so I just want to share that with you. This is not a listed, but I heard them talking about it. I want to get ahead of us that they thought it was grandfathered in.
Mm-hmm. Correct.
But again, if you say the use had ceased for 2 years, then that invalidates that.
Yes, correct.
On the information is
Correct.
but I'm gonna be quiet until I hear from the appellates, so they might could prove that it was valid.
Yeah, of course. Are there any other questions or any other comments that I can speak to or answer?
No, not this time.
You might be talking too much.
Thank you.
Okay. Thanks. Okay. So if we could hear from the Titans.
Are you okay if I remove this?
Yes, by all means.
With my glasses, it's either the glasses come off or the mask comes off, so.
As long as you stay over there.
Good evening. My name is Jason Hickman from Compton and Dueling. I represent the Campbell Trust and the trustees here this evening. I also represented Herb Campbell, and although sometimes I like to think that I'm four attorneys, I was just one attorney that night. I was the attorney representing Mr. Campbell at that meeting. And, I will disagree to some extent with what Mr. Cicero said. A lot of what he said, I agree with. What I will disagree with is that what happened in that case is applicable to the current situation. And it's applicable to the current situation because a lawful nonconforming use is many times confused. I've gone through this multiple times. There's a Supreme Court case from Virginia called Henry Archie versus Prince William County that I argued and won in the Supreme Court, where the Supreme Court agreed with me. A lawful nonconforming use does not mean that you're required to have a business license. It does not mean that you're required to have a certificate of occupancy. A lawful nonconforming use, according to Henry Archie versus Prince William County, means that the use that was established on the property prior to the code being changed or modified or enacted continues. And what you're going to hear tonight is that lawful use continues. Now, I will point out another aspect of this that is somewhat confusing and I think has related to the fact that we're here tonight. This property address is actually 17700 Colonial Port Drive. Road, I'm sorry, Colonial Point Road. That's the property address. The uses on that property have been many and varied over the years. For purposes of history, in 1971, Herb Campbell and his brother Calvin purchased that property. Shortly thereafter, they began to develop that property and used it for many different things over the years. The case that you heard Mr. Tony in 2008 was a case about those uses. The case about the fleet maintenance that was part of those uses. The case about the storage of vehicles and other equipment on that property. And that use that started back in 1971 continues today. And that's part of the sum and the substance of what we're here to talk about. In 2003, the town of Dumfries issued a zoning amendment. And that zoning amendment rezoned this property from M1 light industrial to flex business. If you've ever been over to that property, you'll have to scratch your head and wonder why anybody ever thought that offices would be in that location. But that's for another day. The subject of what we're here about then takes place after that amendment. So everything that was lawfully on that property prior to the 2003 amendment is and was permitted to continue, so long as there hasn't been not a cessation of applying for and getting a certificate of occupancy, not a cessation of not getting a business license, but a cessation of the use. There has to be either an intentional stoppage of the use. Simplest example is I have a gas station. I'm continuing use of this gas station. I pull the tanks out and say, I'm going to make this a McDonald's now. I don't have to wait 2 years then. At that point, I've stopped the use, okay? The other one is the use that Mr. Cicero pointed out, and that's the 2-year stoppage. What that means is that the use of the property that was lawful and non-conforming must have stopped for 2 years. You will hear testimony from Jeff Campbell and Scott Campbell and one of the other tenants there from K&K Auto Body that the use never stopped. It continues today. The use and the people who have been using it have changed. But Mr. Cicero will tell you that your code section at 70-9 of nonconforming uses says it doesn't matter who's using it. What matters is, did the use continue? This was the exact issue that was before the Board of Zoning Appeals in 2008. It was the exact issue that the judge in the circuit court reversed and remanded back to the BZA. And it was, to answer your question, the resultant act was that that particular applicant, GDC, filed for a zoning certificate or certificate of occupancy and a business license that was issued after that. So what we're here to talk about, they've identified it as one of the tenant spaces or one of the unit spaces. I don't know if you saw in the staff report the picture of the particular property. This particular property, if you're familiar with it, it has some bays. And the bays are what's used by tenants for different purposes. The bays in question that Charles applied for, which Mr. Cicero refers to as 17956 Colonial Port, is actually a subset of 17700 Colonial Port. The activities at that location, and specifically at 17956, have continued. They have continued from 2008, where I'll show you in a minute the staff report from John Shaw, who was at the time the zoning administrator, that shows that Quality Carriers was in that location, had a valid business license at that time. I'll also show you notes from John Shaw, the zoning administrator for the town of Dumfries, from April the 30th of 2008, where he specifically goes to the site to inspect it and says that 17956 has a valid CO and business license, a valid certificate of occupancy and business license. The Campbells will appear and testify in a moment that the operations at this location have been automotive repair and warehouse. Whether it was Quality Carriers, who Mr. Shaw inspected and did not violate, by the way, that was not one of the violations. There were others, but that wasn't one of them. Quality Carriers followed by Web Trash. For whatever reason, the Web Trash business license has a different address. Can't tell you why, but the individual from K&K Auto Body and the Campbells will both tell you. Don't know why they put that as the license, but the operations, the use was actually of the exact facility that we have in question, and it has continued. Jeff Campbell will tell you that Mr. Webb couldn't be here this evening because of some medical issues, but he would tell you the same thing, that the reason why Charles applied for the permit earlier this year was because Webb vacated that particular location, and that location is exactly the same location where Webb had been doing automotive maintenance and repair and warehousing. The issue before you is one of lawful nonconforming use. It's one under 70-9 of the Town of Dumfries Code of Municipal Ordinances that allows for the continuation of a use that existed at the time of a zoning, either an enactment or a zoning amendment. In this instance, we have an amendment from light industrial to flex office, flex business and office. And that was in 2003, 2004. The testimony from the Campbells will be that this operation continued. They have records that they'll talk about relative to the usage of the premises. Jeff and Scott both were there on the premises since they were kids, since the early 80s, 1970, going back to 1971 when their father and uncle purchased the property. The situation is, it's difficult, and I understand that. Mr. Cicero is coming into a situation where there's been a lot of turnover and transition. There's not been as good of record keeping as I'm sure we all would have wanted it to be. I can only imagine that there are missing records. That's not unusual in a town. I think Attorney Pandak will tell you, with all of her representation of various towns, it happens. Records get lost, and it's unfortunate, and it leaves us to come here to have to resolve an issue that in reality, I would have hoped we would have been able to discuss and resolve. I have for you, if you would like it, copies of the staff report from 2008, which at page 2 show The address of 17956 owned by Quality Carriers or rented at that time by Quality Carriers as a valid business license. I have the inspection report from April the 30th from Inspector or Zoning Administrator Shaw, where on the last page, he indicates at 17956 Colonial Port, Quality Carriers has the OP and business license. So I'm happy to, Nick, I don't know if you have that as a, okay. But if you would like to see that, it shows it. There were continued operations from that point forward. As I said, the business license, and I don't know why it's written this way, and the Campbells don't know why it's written this way, but the town of Dumfries issued a business license this year. It's dated 2021 to Webb Brothers Trash and Recycling. And for whatever reason, the town put 17962 instead of 65 on here. Again, I don't know why. The testimony will be that the operations were at the actual facility, the same facility or the same location that that Charles came in and put the application in for. Like I said, the witnesses would like to speak. I can answer questions now, or I can wait until they're done if you would like. Whatever is your pleasure, I'm happy to do.
Okay. We'll invite the witnesses to speak then.
Scott, do you want to go first?
I'll take my mask off too. Thank you for allowing me to come up. So what I want to try to do is to establish for you all a timeline. And I went back.
Sorry, can you state your name, please?
Oh, Scott Campbell. Can you hear me? Should I speak down to the microphone? Is this better?
You're good. You can stand.
Okay.
Straight.
So just a brief background. Our father passed away in January of this year. And Jeff and I have really have been coming down to get to know the tenants, to make improvements. And we come down almost every week now. We have our other jobs, but it's important for us to get to know the tenants and understand what they do to make sure that they're in compliance. And we really work hard to improve our father's property down there. So I went back through and I found some of our father's bank statements. And interestingly, it shows Webb Brothers back in 2008, 2009, 2010. So we can establish that they have been there a long time. So in the process of getting to know the tenants, and they're really hardworking tenants, I asked them. I said, I interviewed them, and I asked their name, and I said, how many years have you been at the Colonial Port Road location? And they identified it. And I said, what is your memory of Webb Brothers? Because it's important for you all to understand that Webb Brothers has been there a long time, and they've had similar vehicle repair services. But it's important, I think, for you to have testimony to say, look, we even had Victor, who was my dad's property manager, and he managed, and I said, do you remember? He said, oh yeah. In fact, he said he's actually been at the site from 2006 to present. And I said, what is your memory of Webb Brothers? He said, when I became property manager of the yard and the warehouses in 2014, Webb Brothers were the occupants of the space at the end of the warehouse. And it's important to understand location because there is an issue with the address. And so I said, where, and of course they know Charles. Charles has been there, a while too. He's a mechanic. And I said, so Webb Brothers is at the location where Charles applied for his business license. Oh, yeah. And in fact, and that was important because every tenant that I spoke to, and I said, now, Webb Brothers was where? They are at the end of the warehouse. And so, and I'm happy to give you their, KZ Automotive. I have been in business here since 2014, and I remember Webb Brothers being residents of that space. So, and you're here if, I took photos from my phone, but you're welcome to take them. And so then I asked, why don't you come up now? So this, I know I'm gonna let him say his name because I know I'll mispronounce it.
My name is Kwajo Ntiamwa.
And you've been here since 2007.
Yeah.
And you remember Webb Brothers even back then. Right. And it's interesting because even on my dad's bank statements, there's K&K, which is on his label. We're back in the bank statements the same time Webb Brothers was there. So I hope this helps you see the timeline of the use of vehicle repair services from way back in 2008 all the way to the present, because they moved out, March of 2021. And Charles applied fairly soon afterwards. So I hope this helps, and I'm happy to give you my originals if you want to review them from not every tenant, but most of the tenants. So I hope that helps.
Scott, if you want to, just to clarify,
Uh-huh.
when you say the space that Webb Brothers was occupying, that's the space at the end that we're referring to as 17956?
Yes, and so basically, when Jason mentioned about their bays, so if you're standing at the front of my dad's warehouse, there's a bay, a bay, a bay, a bay, a bay. And the very first bay is the bay that Charles has applied for. It's the very first one there. There's a little row of sort of offices that Quality used, but the first warehouse bay is the first one on the left. And that's the same space where Webb Brothers was, correct? And that's the same space that Charles applied for his business license.
And that's where Quality.
Correct.
Was it?
And what's interesting is that Jeff and I worked for our father over the years. And because I helped my dad with some marketing and so forth. And I remember when Quality was there. And what's interesting that Jeff came and tried to help my dad as well. And he remembers, I guess, when Webb was there. So it's, I've seen since I was a kid being down there, and the uses that where they were all relatively similar vehicle. My dad had heavy equipment, so it's the same similar type of repair services.
Just to clarify, are you familiar with the building that they're referring to where Webb was?
Yes.
And what was Webb doing in that building?
Oh, he repaired the trucks inside and he put his cars and repaired it inside too.
Okay, thank you. And then Jeff, did you want to say something as well?
Hi, Jeff Campbell. And I mainly just wanted to corroborate what has been said so far, but also I spoke recently with Kenny Webb. And although he couldn't.
Can you speak a little louder, please?
Oh, sorry. Do I have to do anything or is that better? Okay. I spoke recently with Kenny Webb, And although he could not be here tonight, I know that he could be available if need be. But he would also, he told me, would also be willing to corroborate that space is the same that Charles is using or has applied for. Because the only reason he's applying for it is because it became available when the Webb brothers moved out. And that the space was being used by the Webb brothers for their repair and upkeep of their fleet of trucks.
Okay.
I'm happy to answer any questions. I do have the 2021 business license if you would like to see that. That was issued for Webb Brothers.
I, for one, would like to see every document that you have that's pertinent to the case.
So are you okay if I come up?
Yeah, it's fine. You have copies of these?
These are copies.
Okay.
That's the business license on the top of the below, just the staff report and the.
Thank you. I'd also like to say what was presented was pretty compelling. However, testifying for someone else who we can't cross-examine, et cetera, doesn't hold well with me. I don't know about the other panelists. If you have someone who has some testimony to offer, I much prefer that person to be here.
And unfortunately, for medical reasons, Mr. Webb couldn't be here.
There were other people cited besides that one person. Whoever is being cited, that person, I would prefer to be here.
I understand that in the perfect world. I agree with you. We are where we are, and it's unfortunate. I understand.
All right.
Any other questions I can answer?
I don't have any. Mr. Tony, do you have any?
I just wanted for clarification. You know, I'm not the sharpest knife in the drawer, so sometimes I get lost and start quoting a bunch of numbers. This address 17796, is that the suite that we are discussing?
So the address of the overall property is 17700.
I understand that.
The address for the property in question is 17956.
17956. So what we have is it's sort of a large building with tenants, and each tenant has a business that is a conforming business. Am I correct?
So it is a lawful, non-conforming business operation.
So all of the tenants have a lawful, non-conforming business.
As far as I know right now, every tenant there has a lawful, non-conforming business.
Do we have evidence that all of their business license, well, first of all, they were grandfathered in?
So the lawful non-conforming use is synonymous with grandfathering. Okay, that terminology seems to be crossed over, but for code purposes, it's called lawful non-conforming. I think a lot of people in generic language refer to it as grandfathering. Okay. So the uses that are there that are related to the M1 light industrial that have continued since the 1970s, those continued uses are lawfully non-conforming.
Got that.
Okay.
So you said the Webb brothers were the tenants that moved out?
Right. It was Quality Carriers, then Webb Brothers, and then Charles, who is the person who filed the current application.
There was no break in terms of
no, Quality Carriers who was identified by Mr. Shaw in 2008. As Mr. Campbell indicated, starting in 2008 and thereafter, Webb Brothers took over that space and continued to lease it from 2008, 9, and 10, and is continued until March of this year.
and all of these tenants had current occupancy permits and business license.
So the interesting thing is an occupancy permit, and we may disagree on this, but an occupancy permit is only issued at the time of construction and occupancy, or if there's a change in use. So when they're saying that they want to confirm the occupancy permit, they're not issuing a new occupancy permit with a new name on it. The occupancy permit continues because it's a lawfully continued use. So I have a slight disagreement with Mr. Cicero that they issue a certificate of occupancy. What is required for a lawful non-conforming use is simply that the use continue. And under the certificate of occupancy, the section that is actually appropriate for this discussion is that once you have the certificate of occupancy, a new certificate of occupancy is not issued until there is a change in use. And in this instance, our contention is there was no change in use. And that's specifically found at 70.9 under C1, when required, in subsection B, change in use of an existing building. That would be the time when a new certificate of occupancy is required. What they're doing is verifying that the use is appropriate for the zoning. And so if you look at the actual denial that's attached to the application for appeal, the denial, which was an email to my clients, said, this is not this, the automotive repair and warehouse is not a flex business and office use. It's not permitted under that section of the code, and therefore it's being denied. However, what we're suggesting is what they didn't evaluate was the lawful non-conforming use aspects of this, which would have allowed the certificate of occupancy that was already in place and documented by Mr. Shaw to continue at that premises for automotive repair and warehouse. That was a very long-winded response, Mr. Tony. I hope I answered your question.
You may have in this one. But the other thing too, when I wanted Mr. Cicero, because I think I remember reading wherein the new applicant is seeking to, if I remember correctly, to repair cars and then store them outside while he prepared to ship them out of the country. Does in your Mr. Cicero, in your opinion, and I saw alluded to there someplace, would this constitute expanding that use?
It might be useful, I hate to interrupt, Mr. Tony.
Please.
Finish your questions to Mr. Hickman.
Okay. But well, I'm through with Mr. Hickman because I want
just so
okay.
they don't have to do up and down.
Okay, I got you. Yes, thank you. Thank you for
Sorry to interrupt.
Okay. So any more questions for
Yes.
for Mr. Hickman? Okay.
Besides the 2021 business license, is there any other hard documentation affirming that the use of the business has been the same within the past 2 years, such as invoices that you've provided for us?
No, there's not.
Thank you.
Unfortunately, that was not something that was asked of us. And I will have a small bone of contention with Mr. Cicero. He put in there that he asked us for certain documentation. I was shocked when I read that. And I actually went back and read all of my emails, which is how he communicated with me. And that was never requested. That being said, what we put together today was what we could gather quickly in response to the staff report saying that there wasn't documentation.
Do you know if it exists, period?
I would have to go look. I have a huge file on this particular premises, which is why I have the documents that I just handed to Mr. Thornton. There is a lot that has gone on at this location, and I know that there's been challenges with that property. I would have to go look. I don't know that Mr. Cicero actually looked for a business license at the address that it was issued to. And I don't know why it was issued to an address that is different than the address that we're talking about, but it was. If you look at the business license, you can see it was issued to a different address, but it's for Webb Brothers. And as was testified to, that was their location.
Thank you.
One more thing, what I understand is the documents that you're providing are going to be able to verify that there was a continuous use. Is that not the case?
I think the documents in conjunction with the testimony do establish that. And again, I'll point back to the case from 2008. This is exactly the same situation that we went through. And when the circuit court heard the testimony again, reversed it and remanded it back here with a direction to allow the certificate of occupancy and the business license to continue.
That information here in these documents,
Is what information?
what you just stated about what the court had said.
It's on the appeal. At the very last document on the appeal is the judge's order reversing and remanding the BZA. Not in that, in the staff report. Did you not get a staff report? It's in the staff report.
I didn't recall it being there. Basically, it all seems to center around one thing: a proof of continuous use. And so the more you can present that that is true, the more I'm obligated to think that this has some validity on your side. The less you're able to present that, the opposite is true.
And I have an extra copy of that order. I can bring it to you.
Thank you.
I'll just take it off of mine.
Thank you. Oh, yeah, this was there.
Thank you. I appreciate your time.
Okay, thank you, Mr. Hickman.
Thank you.
Did we have a question for Mr. Cicero?
Yes.
Hello.
Yes, Mr. Cicero, if I remember, if I recall correctly, but you also noted that one of the reasons for denying it was because the use that was being proposed would constitute an expansion of the use.
Correct.
Could you elaborate on that?
Yes, correct. So from the Town of Dumfries zoning ordinance in section, let me grab it. It's part of the appeal packet. And I also would like to note in front of you in the folders is the agenda packet for tonight as well. So that will have all of those sections as well. And section 70-576 continuation. Apologies. Yeah, in regards to that, if you look at the very back page of the it will have the continuation. No such non-conforming use and or structure shall be enlarged or increased nor extended to occupy a greater area of land than was occupied on January 18th, 1979, or at the effective date of any amendment to this chapter. And as I showed you on the picture in my presentation of the aerial image, you could see that the amount of cars that are currently there, the storage of cars would increase the non-conformity of the property if it was a lawful non-conforming use at the point of if it was considered a lawful non-conforming use. At this point, from town staff's interpretation, it is not a lawful non-conforming use. And I also would like to add as well for this to just address some comments about the property address. The reason the property address is confusing is each tenant space within that property has its own address, but it's all under one parcel ID, which is included in both the staff report and the public hearing notice as well. This is all under one parcel ID. And when we have applicants come in, it is on them to fill out the application. And I just, when it comes to this appeal, that was the address that was put on the application, which is why the appeal is for that address. And that's why I included the 17700 address as well, because that is the address for the actual parcel. And I admit there's some confusion over, and that's occurred from over the years. And unfortunately, I wish I could go back and, clarify all this, but that's just the way that it was written on the application. And also just to add, I did in the response and provided in the comments to the applicant, Charles Aquacom. I'm probably saying it incorrectly. I apologize if you're at home paying attention to this online or watching. I also spoke to his wife as well on the phone, and I explained to them, this is what we need. And I told them, if you provide this to us, then we could proceed. And that's when, at that point, I had received an email from Mr. Campbell. And throughout this process, I just would like to point out that this has been working with them has not been contentious at all. It's been very civil, and it's just, it's just where everyone's doing their part in this, where we all have our job and role that we play. So I just would like to add that as well. And trust me, when it comes to this sort of thing, this is a property that, again, like you said, Mr. Tony, this has been before the BZA before. So, and that's why I wanted to be as clear and concise as possible with this. And I just like to add a few more things as well with that, just to speak to the Head Brothers trash hauling company. That is a primary use of that tenant space was for trash hauling. It's not for automobile. It was not a repair shop. It was a trash hauling company with an office, because it's an accessory use to fix those types of vehicles. The only use that could be continued as a non-conforming use is the primary use of the property or the tenant space. Just because it's an accessory use doesn't mean it can become a primary use, therefore leading it to be non-conforming. Because the primary use of the property, as it shows on the business license as well, trash hauling. It's not an auto repair shop. It's not K&K Automotive. It's for trash hauling. And that's been the use there for years. And that's something that I found on my research as well. I have 5 full-size boxes of information on this property dating back to 1975. I've dug through that, spent countless hours on that, and I was not able to locate any valid COs or COs or business licenses from the last 2 years that were active regarding and that were similar to this use, auto repair shop, anything regarding auto care. And then I'd also like to add too that just to add that this issue at hand before you deny is just regarding the denial of the CO. It's not the non-conformity of the entire parcel itself. It's the denial of the CO on the interpretation that it's not a legal non-conforming use, because we asked them or staff asked them to provide documentation such as a business license or CO, which is town ordinance. And that is what the zoning administrator or as I currently serve as the acting assistant zoning administrator, I'm allowed to ask for in terms of issuing certificate of occupancies. And that is information to prove that in non-conformity of not only the tenant space, but also the use as well. And at that point, that is why it was rejected and denied.
The primary use as king is an interesting concept I hadn't heard throughout this before. Thank you for that.
You're welcome.
That's important information. I think there's a denial here.
Yeah, can I just want to clarify something, because I want the record to be clear.
I think it's helpful to sort of let Mr.
Cicero complete, yes.
Yes.
Yeah, otherwise, I just, you know,
I agree.
Thank you, thank you.
Thank you.
I apologize.
And no, please.
Thank you.
But I didn't know whether you all had specific procedures, and I just think it adds some clarity.
I do.
I agree.
And
Any more questions for Mr. Cicero or any more comments?
To be clear.
Okay.
You know, again.
I have just one more comment.
yeah, of course.
I'm sorry, go ahead. Finish.
Up to you.
A lot of statements have been made by the presenter here.
Yeah, of course.
What points do you have to refute what he said? You
Yeah.
brought up one very basic point of the primary. Are there any other particular points that you'd like to make?
Yeah, so when it comes to the same use continuing, it's not a legal use if, per town ordinance, if you don't have a CO or a business license, you are operating illegally within the town of Dumfries if you don't have either. And for our records from the last 2 years, I'm again speaking to the last 2 years, I understand that there was a decision made in 2008, but for the topic at hand tonight is from 2019 on. 2019 on, there's no record of any lawful non-conforming use being active at this property or within this tenant space. More importantly, just because there is another tenant bay that had a similar use, we have to look at how the operation of this proposed use would entail. And like as I stated in the staff report, because it would be enlarging the nonconformity, that if it was a lawful nonconforming use, if it was enlarged, or because they are planning on storing vehicles outside and also doing auto repair activity within the tenant space and outside, then that would be an enlargement of the nonconformity, which is not allowed per the zoning ordinance, which is king when it comes to this sort of thing. The town Dumfries zoning ordinance is the one who makes the rules. I'm just enforcing it. I can only do what the ordinance states. And then also, I just like to add to, the testimony from the Campbells and also the gentleman as well. They don't, it's not testimony that they did not provide an affidavit, legally signed affidavit. So this is something that this is a public hearing. This is something where that would be considered public comment. It wouldn't be legally binding from my understanding of the law and from what the town attorney has said. Correct me if I'm wrong, town attorney. But just because someone says that something existed 12 years ago doesn't mean it's legally binding. I could say that about anything that I've seen in my life. And it's not law. It's not law. Something when it comes to this, again, this is something that we should only be looking at the last 2 years, not the last 13 years. In the last 13 years, the last time this was heard, I'll be honest, I was 11 years old. So this is something where I'm sorry to make everyone feel old in the room. Again, I apologize.
I am old, so.
But yes, just this matter at hand. And again, this is just something I just wanted to present it as clear as possible. I think I've done so. And if anyone has any other questions, I just would like to conclude. Okay.
Just one more.
Yeah.
This is not really the subject of this meeting.
Yeah.
But is there anything that the plaintiffs could do, the appellants could do to correct what has already happened?
That's a great question. And in reality, it's just they would have to possibly go back and rezone the property to M1. They could go back and do a rezoning to M1. Again, that's a long and tedious process, and I don't want to put them through that just because of something like this happening. When it comes to the nonconformity of this, it's up to them, and it could be a tedious process. And like I said, it's something that would be heard at public hearing, and the town council would have to support it as well. I would be able to provide a staff report on that, or our department would provide a staff report, but ultimately that's the town council and the planning commission to make that decision. And again, while that could possibly happen, I think for what we have here tonight, it's something that the best option to move forward is just to have places or have businesses come in that are permitted in that zoning district by right or through conditional use permit, and get and apply for and receive certificate of occupancies and business licenses. Again, I'm really easy to contact, either by phone or email. I respond pretty quickly, and I'm always happy to help a new business come in to the town of Dumfries. We welcome all types of businesses, and just as long as they are, just as long as they follow the proper protocol.
Change the business model and they got an in, is what you're saying.
So the question I have is from what I understand, this is one large business, right? This is one large business that owns the building and then rents the spaces to individual businesses.
Correct.
To run within there. Okay. That's what we're talking about.
Correct.
Right? And so what we've heard tonight is some of the individual businesses working within there. For example, the Web and K&K and that they've continued to work there, but has there been any paperwork or any oversight of the business as a whole? What's the name of the business as a whole? The whole building that you have there?
Well, it's the trust has had that. My father's had it for years.
Okay.
And so he's rented out individual bays with similar vehicle repair services.
Sure.
Over the years. And so the vehicle repair services that Webb did when they worked on their vehicles, trucks or whatever, it's industrial, light industrial. And so that's the same use that Charles will be doing, vehicle, engine repair services. So it's been that way for all these years.
I understand. They have many, what do they call, I guess, parks or whatever around the area where they have a large building and people rent space for various reasons. And I've seen, vehicle repair set up beside a brewery for different reasons. But usually it's one overarching business in there, right? Usually there's basically all these individual businesses. Yes. They have to pay rent to somebody, right?
Correct, yes.
What's the name of the business that they pay rent to?
Well, it's the Herbert Campbell Trust.
Okay.
Who owns the property, who owns that building. So it's it's not a name, it's the Colonial Fork Road building that individual businesses who have. I think a lot of the other businesses down there have business licenses.
Right.
And
I imagine they would.
So it's just a continual use over the years of similar type of vehicle repair service, truck repair service. It's all the same type of vehicle. I use that term loosely. Vehicle repair services is pretty much all the same type of business uses that have been in that building for many years.
Are you asking what my dad and his brother, their business originally?
Yes.
Oh, no, the reason they built these warehouses, the smaller warehouse next to it, that was their business, room office. Yeah. And they had a first moving business.
They had a, I'm sorry.
First moving.
Okay, can you come up here? If you would, please.
Oh, yeah, of course. Let me put on my mask.
I'm sorry.
So my father and his brother started their earth moving business originally in Fairfax County
Okay,
and moved down here to Dumfries, built the warehouse. And the warehouse was used for repair of the bulldozers, pans, cranes, and what have you, as they went out on different jobs.
sure.
But when they retired their business, and they built the green warehouse just as an investment. And when they retired their business, they also rented out the yellow warehouse. So I guess there's no real overarching business now. It's strictly the tenants, the individual tenants in the buildings.
All right, thanks.
I'd like to remind the chair that we had speaking about the primary businesses as opposed to the auxiliary businesses that were taking place.
Right.
So what I gathered from what he just said is that these are auxiliary things that were going on originally to support the father's basic business, which was moving earth. Two things are integrated in that way. So the earth business at first, the moving of the earth business was the primary, and the repair of the tools to do so was secondary.
Sure, sure.
And I'm going to take issue with that. I'm going to take issue with what Mr. Cicero said. First of all, the business license does not say what he said it says.
Okay.
The name of the company is Webb Brothers Trash and Recycling. The business that's listed on the business license says flat rate repair per business. They are there in that place to do automotive repair and warehouse. The primary use, I don't know where this accessory thing came from. I don't know what that argument is. The primary use, the only use in that premises for Webb Brothers was automotive repair. The use, and this goes back to the exact issue from the 2008 case. And Mr. Tony, I think you're the one that actually asked me this question. And you said to me, does it matter that they don't have business licenses? And I told you then, and I'll tell you again tonight, it does not matter. To be legally non-conforming, you do not have to have a business license. That's exactly what the court said in their decision. That circuit court decision was not appealed by the town of Dumfries. That decision was reversed. The decision of this board was reversed and remanded back here because the decision of the board that night was, well, they didn't have business licenses, therefore they can't be lawfully non-conforming, so therefore we must deny. And that is not what the circuit court says. The circuit court said the testimony, and the only testimony that you have before you tonight, is that the use of this property is as an automotive repair garage and warehouse. That's the only testimony that you have. Mr. Cicero even said.
I beg to differ, sir. He just told us about what his father's business was about. It was about moving earth. And the father then used the property to also service those implements that were helping to move the earth. If I am to believe, accept, understand what was said about primacy and auxiliary, that would fit that description.
So, and let me just clarify. He's talking about what happened in 1971, which I would differ with you, but it's irrelevant. What's relevant to what we're talking about today is what were the uses in 2003 when this particular zoning was changed? And the uses from 2003 continuing through 2021, you have heard testimony was automotive repair and warehouse. That's the only testimony that you've heard. And in fact, the town has even substantiated that it was automotive repair and warehousing. John Shaw said in the documents that you have, this particular location continued with an active business license and certificate of occupancy for, as was testified to, automotive repair and warehousing. There's no other testimony that has been offered. This is the exact same issue from 2008, where the judge even said, what information do you have? What evidence do you have to contradict the testimony? And the town at that time had no evidence, and today has no evidence. I don't want to go back to the circuit court and do this again. These people are trying to run a business, and all they're doing is continuing to run a business. They've had their tenant apply for the certificate of occupancy and business license because that's what the town wants. They're trying to do this the right way. They're trying to be lawful and not have problems. There was no testimony that they're changing the use. Mr. Cicero said something about storing of cars. The entire property is storing of cars. You saw the photograph that they put up there. Look in the staff report. Storing cars is what is on that property. That's not going to change the use of this property. The tenant subspace that they're talking about, because now we're going a little far afly. We're going from, okay, no, it's the use in this space, and the use in this space of 17956 has to be automotive repair. Now they're saying, no, we're talking about what's out in the yard. Well, then let's talk about 17700 Colonial Port, and let's talk about what's already been established in court. It is a yard. It is automotive service repair, and it is and has been since 1971. I've got photographs that I don't want to bore you with that show this property from 1971 when it was constructed up until the current. There are cars there. That's what's there. That's what this is. That's the whole point of the 2008 case. We can keep doing this, but the reality of it is the lawful non-conforming use evidence that you have before you is the testimony of the owners and the tenant that says there's automotive repair and warehousing going on at this property at this location. Whatever the addresses are, that's what the testimony was. There's automotive repair and warehousing going on. And that's all we're asking to continue. This isn't an expansion. We're not saying, okay, there was automotive repair here, now we want to do it over there. That may be okay actually under the law, but that's not even what we're asking. We're saying there's automotive repair right here, and we want there to continue to be automotive repair right here. There's warehousing that's right here. We want the warehousing to continue right here. This isn't an expansion. The expansion argument is a nuanced argument, but that we don't even have to get there. That is not what this is about. This is about what's going on in the space that was identified by the witnesses, and what's going on there is automotive repair and warehouse.
So if I go down there tomorrow, that's what I'm going to see taking place?
Yes.
In all of the spaces.
In all of the spaces. Can I hear from the town attorney on these matters?
Thank you. I'm sorry.
Thank you.
Thank you. I appreciate your attention.
Yes, Mr. Thornton, are there specific questions you want to ask me, or you want me to?
Oh, we
do a
just went
rundown?
through a whole long list, and I'm sure that you were sitting down there taking notes and had some type of remark that you have for each one of them. I'd like
Well,
to know
I
what they are.
do. I'm deferential to Mr. Cicero, but if you want to hear me go through the list pretty quickly, I will.
Thank you.
Be glad to do that. And in some cases, he's already advised you of these matters, and can do so again. I think he has already discussed with you that a use is not legal if it doesn't have a certificate of occupancy or a business license. So the fact that there may have been some uses out there that he says continued to be automobile repair and storage, if they didn't have any COs or business licenses, let's even assume they otherwise were there, then that doesn't make them legal. He cited a case out of Prince William County that related to a specific ordinance in Prince William County. I don't think you should take that as being necessarily relevant to the town of Dumfries ordinances and their applications here. I think Mr. Cicero has already discussed the issues of property addresses with you and why there is some confusion there perhaps as to the specific numbers of the units, but that he has not been able to demonstrate that there were legal non-conforming uses for this particular aspect or bay that the applicant has raised. I might note that in that regard, that it's not the obligation of the planning staff, the zoning staff, the public works staff to ask the applicant to provide specific evidence. They did. Mr. Cicero testified that he in fact did speak to the applicant's wife and asked her to provide certain things. Certainly, whether or not that was the case at the time of the application, this is a public hearing that's been scheduled for some time. Mr. Hickman is a quite qualified land use attorney, and he knows what he needs to bring into these BZA hearings in order to demonstrate to you the type of evidence that would prove that there was a legal non-conforming use. Moving a little further on that regard, with respect to the testimony that Mr. Campbell has given about what tenants supposedly told him, you all know that that is what is legally called hearsay. It's somebody else telling somebody else. It's kind of the telephone chain thing. The purpose of having a public hearing is for evidence to be submitted to you that you can consider to be credible. And so, you know, notwithstanding the fact that there may be medical, there may be other reasons, there is the capability of getting affidavits. Those are traditionally what's provided. They're sworn to and brought in paper if a person can't specifically testify. With respect to the gentleman whose name I regrettably can't pronounce, and I do apologize, I will call him Mr. K. I do apologize, sir, that his testimony was not specific. It was general. He didn't speak to the specific timeframes that are relevant here, that you have to show 2 years of a valid non-conforming use. He simply just said generally, didn't speak to specific land base either. The same was true generally with respect to the testimony by both of the Mr. Campbells. They kind of sweeped over and said, yeah, it's always used to be there. That's not the issue that needs to be established. You need, as Mr. Cicero told you, to establish that there's not been a cessation of a use for 2 years, though, that has continued to be a legal non-conforming use and not ceased for 2 years. You don't have that. You have some vague generalities. To the issue of that was raised by Mr. Hickman, that maybe the flexible office zoning is not appropriate. You saw the picture that Mr. Cicero put up there. That's not an issue for either the applicant or the BZA in this matter. Although I'll say it's a determination for the council as a legislative decision if they want to change the ordinance. You as the BZA, as Mr. Cicero, are stuck with what the current ordinance says and what the current zoning of the property is. And that's what you have to look at. Nothing precludes the Campbells or the applicant from seeking a change in the zoning of that property. They can come in and do this. Mr. Cicero kindly referred to it as tedious. I'm sorry, the town of Dumfries processes for rezoning considerations are actually quite fast. If you look around the region, and that's just the way it is. If you don't like the zoning you have, you come in and you ask for it to be changed, and you demonstrate, if it can be demonstrated, that there's another appropriate use for that property. With respect to the issue of lost records, it troubles me as well as it does everybody else, but I will say a couple of things in that regard. As I noted first, and I believe both Mr. Thornton and Mr. Tony, you noted, the transcript from 2008 really isn't relevant now because the legal nonconforming use still has to be established as not having ceased for 2 years and ongoing up to present. That's not been demonstrated either at the time of the application for the certificate of occupancy or presently. The second thing with respect to that court process that Mr. Hickman referred to in 2008, if you look at that order, you really can't tell what went on in court other than it was reversed and remanded. We know that there was never a final determination that this was a legal nonconforming use. That we don't have anything in writing that says that. We don't have an indication that the Board of Zoning Appeals determined that, but let's just hypothetically say it did happen in 2008, hypothetically. We still don't have it demonstrated that that's continued to be a legal nonconforming use without cessation between 2008, when Mr. Cicero was a small child, and present. Okay. At most, we get to, I think, by considering the various dates that Mr. Hickman did give you, we got to 2010, which is still 11 years ago. And I think with that, unless you have specific questions, I believe I've covered all of his points. I'll be glad if he raises some more to come back up here.
I believe you covered the field very well. Thank you.
Thank you.
Before you leave, I'm sorry. I think one of the contingency, and I do, back during that hearing that you alluded to, Mr. Hickman, because that was a point of contention with myself, because about the business license and whatever, because at that time, Mr. Campbell had several of his tenants did not have business license. That's why I asked you, and at that time, as you may have recalled, you stated that that was not a requirement for the continuation of the non. And I'm hearing you say, I'm sorry.
That's okay, Ms. Pandak.
Ms. Pandak, yes, thank you. I'm having them senior moments.
Yes, sir, I'm sorry. No, I don't have my sign on. I have my badge.
That's okay. But you were saying, and I thought too, this is a requirement for of the ordinance for the town of Dumfries, that these one or either both of these things exist, either a certificate of occupancy or a business license. Did I hear you say that?
That's what Mr. Cicero has indicated, that is in fact the requirements of the town of Dumfries.
Okay, that is what we based our decision at that time on. And I'm hearing him say that he argued for before the Supreme Court. I think that was supposed to put us on notice that that is, and the Supreme Court of the state determined that those two things were not necessary.
Yes, Mr. Tony, just because the Supreme Court determined that in the case of Mr. Archie, who is or was a business in Prince William County, that's under, as you know, the county has a separate zoning ordinance. And so I don't think that you should assume that case is as relevant. And having argued before the Supreme Court numerous times, as I'm sure Mr. Hickman has, we know that facts matter and that laws matter. And in terms of how a particular case gets determined. The other thing that I didn't add, but you remind me of, is that, and Mr. Cicero can speak to this further if you want, that there are issues and have been issues for some period of time of other violations by the uses that are out there of the zoning ordinance. We've tried to streamline this down. I believe that's what his office has in terms of looking at the issue of legal non-conforming uses. But when Mr. Hickman says, well, there are cars all over the site, you should ask the question, and Mr. Cicero will tell you that that's not consistent with the town zoning ordinance and other regulations that are applicable as a matter of state law. And I'll let him detail that further if you want to. That's not the specific issue before you today, but it certainly is a matter that can be considered, is that what is going on out there is not consistent with the town zoning ordinances, separate from the issue use.
Thank you for the clarity.
Yes, yes. Thank you.
Sorry about that again. Yeah, and just to add to that as well, I do have the certificate of occupancy section of the zoning ordinance. If you all would like to look at it, it clearly outlines when a certificate of occupancy is required. Is it okay if I bring this up to you, or is anyone interested in?
I'd love to have a copy.
Please.
Yeah.
Thank you, sir.
Was that attachment 5?
That is not attachment
Okay.
5, but I could provide. I did not print out enough. I did not print out enough copies of that. I apologize, but
Could you summarize that?
yeah.
Oh,
So
oh.
basically, anytime any space, tenant space, or structure changes use, or even if any parcel of land changes use, you would need a certificate of occupancy in order to occupy the space, and in order to ensure that it is in conformance with the plan, with the comprehensive plan of Dumfries, the town of Dumfries, as well as the zoning ordinance. Again, the reason that nonconformities exist is because the one reason, I don't want to say it's not why they exist, but one of the reasons that they negatively impact a town or county or whatever you may call it, is the fact that it gets in the way of attaining the comprehensive plan goals set forth by the comprehensive plan itself. And also, it's not in line with the zoning ordinance. It's impeding the goals of that property, that are the goals of that parcel of land or that property in question. When it comes to that sort of thing, the reason we keep the certificate of occupancies on file is because we need to verify and keep track of what is permitted and what is going on at that property. If it's property suite, for example, so the town of Dumfries owns this building. We have to ensure that every tenant within this building has a certificate of occupancy and that it meets the parking requirements. It meets every aspect of the zoning ordinance. It's in a way, it's the same aspect of this property at hand at Colonial Port. You have one large structure with multiple suites or bays in it. Just because it has one, just because it changes use over the years doesn't mean, just because something continues over the years, such as these cars, which is a whole nother aspect, or the storage of cars outside and on this property, that's a whole nother aspect that I do not want to get into tonight, because that is something that Prince William County has also provided in the past, fire code violations that are not relevant to this appeal tonight. The entire property is also in the RPA zone, is in the resource protection area, which is not allowed now. And along with that, if you would like, I could provide you with a letter signed by Herb Campbell himself prior to his passing that he sent to his tenants in regards to any violations on the property / nuisances being fixed. And also he sent one to the town as well, because there were multiple violations. I don't even want to get into what beyond the zoning aspects this property violates. But also that this was from 2019. This is from February and January of 2019, the last 2 years, where they admitted that there were issues at this property. If they were attempting to work with the town at that point, they should have came in for COs and business licenses to continue this non-conforming, to continue the uses. But as we've seen tonight, they have not been doing that consistently. And to be honest, it's something that as a town we need to improve. We need to improve on to to all businesses to ensure that they know the rules and regulations. But also, we do now send out every year the requirement to fill out a business license application every year and to renew it.
Mhm.
And just to add to that as well, I don't know if you all would like to see these letters that were provided to the town by Mr. Campbell, or if you don't want to see them, it's understandable, just regarding the violations and such. But yes, just for the issue at hand tonight, this is something that, there's a lot of, I just feel like we're going back and forth regarding this tonight, and it's pretty straightforward. We asked them for proof of nonconformity. They didn't provide it. Therefore, we denied it. We denied the CO application. I don't want to get into the, I don't want to misconstrue what this process is. It's very straightforward. You apply, I provide comments, I receive the comments back. All that was argued was that it's a non-conforming use. No, I was not provided with any evidence. The town was not provided with any evidence, and it's on the applicant to do so, or the appellant in this case to do so. And I was not provided with anything. And I understand that while the town is the main record keeper, it also is the responsibility of a property owner to keep track of, and landlord to keep track of what is operating at their property. Because in the long run, if anything were to happen there, it's on them to ensure that everything is legally operating.
Mhm.
And that is all I have.
Mr. Cicero, are you finished? Yeah. Yep. Bless you. We have,
Come on up, Jeff. That's okay. I would say to you, and I have never said this before in all the years of doing this, that was the most appalling thing that I have ever seen. To bring up things that are completely irrelevant and just throw out to you that there's all these violations on this property without any proof or substantiation of the fact, it is improper. And it shouldn't be before you to even have considered it. I cannot believe that was just given to you. The sum and substance and circumstances surrounding a letter when Mr. Campbell was dying, that's what he wants to bring before you? This is ridiculous. The whole statement about all these violations on this property, then where are they? Why are we not here for all these violations? If there's all these violations on the property, why don't we have them? Don't come in front of this board and say, this is a horrible tenant, a horrible landowner in this community because they have all these violations, and yet you haven't cited them for one. Every violation that was ever on that property has been resolved. And that is what they should be saying. Not that this is a horrible property and this is a horrible family and they do all these horrible things and they don't have COs and business licenses. I cannot believe what I just heard. And I apologize, but that was completely, I don't know where that came from, and I have never experienced anything like that before. Talk about hearsay. What about relevance? How is that relevant to what we're here to talk about? Go ahead. I'm sorry.
I just want to set the record straight. I was called in to aid Charles in his application when it was questions and were raised, and it was denied. And then you can check the record with Mr. Cicero. Between myself and him, they were asked, the main question was to establish that the previous use was for vehicle repair, engine repairs. And I did send the business license that you all have to Mr. Cicero. Initially, we submitted an archive request to the town, and that was ongoing. However, I called Mr. Webb and he gave me a copy of the business license, and I emailed that over to Nick. I'd like to make one other point about the continuous use of that space by the Webb brothers for vehicle repair. My brother mentioned that he has bank statements from the Webb brothers, or showing the Webb brothers rent back from 2008. And the business license in 2021, I would think, pretty much shows that that space was used by the Webb brothers for that period of time. There has been no cessation for 2 years or any time over that period of time. Thank you.
Yes.
Mr. Chairman and members of the BZA, you've been very patient, and so I hate to come up again. And but I do think that probably the town gets the last word anyway on this, but maybe I'm wrong. I want to mention Mr. Hickman has indicated great anger and insult, I suppose, by the fact that violations were mentioned. But I don't think that would have come up unless he indicated to you earlier, and maybe I misunderstood, that there were vehicles all over the property and they'd been there for a long time. If they were in violation of the town zoning ordinance or other state law, then that raised the whole issue of whether they were legally all over the property in conjunction with this allegedly legal non-conforming use. So that's why, and Mr. Hickman, you note, did not even raise the issue until we brought up that point. So I did want to indicate that, and since he seemed to be so exercised about the issue. Thank you.
I'll make a few words. When you talk about cars there, the tenants, what they do is if they have a car to be worked on and there's throughout there's yard space, because yard space is considered contractor storage space. And it's important for the tenants to have the space when their customers bring a car to be worked on, whether it's body work or whatever. So when we talk about the cars that are on there, these are cars that these businesses need to operate to make a living. And it's all part of the continuous use. Ooh, that switched. And so when that's just part of the contractor storage. That's what these businesses work on. And we're, my brother and I are there, are trying to, we want them to organize it, to be in a space, and that is a use that they need for their repair services. People they bring their cars in, they line them up, they work on them, they go to the next car. So when there are cars there for their use, and that's important for their livelihood of their businesses. So when you talk about cars being, it's not like they're just thrown out there. These are cars that these businesses work on, and that's all the whole part of the continuous use of these businesses. Anyway, thank you.
Thank you.
Yes, please.
I just want to say, I was not aiming to, anger the appellant. That's not my point. That's not my goal of this. I just wanted to bring up and respond to something that was brought up by them themselves regarding that use. And again, the storage of the cars is not what we're considering tonight. Right. And I think at this point, we're just going in circles, and I feel that it's best that we close this public hearing. And at this point, I just want to reiterate that when it comes to violations and this sort of thing, I am the planner. I am not the code compliance officer for the town of Dumfries. I'm the planner. And when it comes, what And again, what we're considering tonight, this was a certificate of occupancy application. This wasn't a violation or appeal of a violation. This was a certificate of occupancy, which the Department of Planning and Community Development will review every single certificate of occupancy that comes through. And if you don't need it, if it's not required to be a legal or lawful non-conforming use, then why was one apply? Then why would they apply for one after so many years of not operating? That it's at this point, I feel that it's best that we close the public hearing and allow for any comments from the
Chairman, I would like,
That's.
Chairman, I'd like to move that we do close this meeting now.
That's what I was going to ask. Is there any closing statements from anyone before we close the meeting? Okay. So the meeting is now closed. What do we do next?
Make a decision. Okay, discussion.
All right. I think we do.
No.
Sorry.
And I would concur that you need to have your discussions in a public forum.
Okay. Thank you.
A matter of procedure, what is our next step in the closing of this meeting?
Whether or not you're going to uphold the denial of a certificate of occupancy, that this is not a legal occupancy. That is, you're going to have to make a decision on that issue.
Okay.
So we can't table this for lack of adequate information, because we feel that additional information would better give us a more help us.
I would concur with that. I would like to look over some of the statements that have been said and see how they match each other. I've heard from a lot of different sides, and to make a decision based just out of the air, I think is not appropriate in this case.
Mr. Chairman, I think to Mr. Thornton's question, perhaps, and Mr. Tony's, I think the first issue is you have closed the public hearing unless I misheard that. The second would be, can you table it in order to review the information that's been presented to you at the public hearing? I think that is a possibility that you can do that.
Okay.
So if you decide to do that, I'm understanding that perhaps you've not had a chance to review all the material that's been presented to you. And so you could defer for that purpose. And then the third is that you would make a decision tonight to either uphold the determination by the zoning administrator with respect to it not being a legal non-conforming use, or if you would find that it was a legal non-conforming use. So you would either grant the appeal or deny the appeal.
So I think at this point, we'd like to table. Well,
It's closed. It's already
already
closed.
closed it.
It's already closed.
It's already closed?
Yes.
All right.
So yeah, we'd like to table this decision until.
That's a, yeah, I think Mr. Hickman and I are going to agree on two things tonight, so I appreciate it. If you are tabling, if you plan to table it, then you do need to come back to a public meeting in order to make your decision.
Okay.
That's why I I always hate to tell people that they can't talk off the record, but you are here as a deliberative public body. So you would have to come back to make that decision. You couldn't just simply write out a decision, and sort of pass it to Mr. Cicero.
We had no intention of doing that.
And Mr. Cicero may advise you further with respect to our processes. So I defer to him in that regard.
No, that's right.
Did you?
I make the motion that
Okay.
we table it. Okay, bam, somebody. Second. We have a motion. Do we have discussion? Okay, then after we discuss it, we can discuss why we want to table it and then what we feel this.
Yes, we do that. We do all that in public.
Was that?
We do all that in public.
Yes.
I shared with my colleague that I would like to make the motion that we table this matter. And once we vote on this motion, that during the discussion, maybe we can talk a little bit about the things that we feel is be necessary to help us make a more informed decision. That's a date for the next
Yeah.
meeting.
That was good. Yes.
Okay, so I'll make the motion
Okay.
that this matter is tabled tonight due to the want for more information. Can I get
Or
a second?
verify information.
Okay. Second. Okay. And you need a vote on this?
Let's get some discussion.
Aye.
Okay. Get some discussion. Any discussion from
Further
anyone?
discussion? Well, for myself, I heard several, and it's clear to me that there's some discrepancy regarding the town's requirement for occupancy permit and a business license for the granting of this, or for the continuation, but just to get that whole matter clear. And I just think that we need to discuss it a little bit more. And I think you said you had some more information. And also the appellants. If they, I think the attorney was quite eloquent in this pandemic, in sense, talk about affidavits, and be serious in your approach when you come here, knowing what's necessary to get a good informed decision. If we had to continue the meeting, I just think that, and give us some clarity,
If I might, and then I'll leave it to Mr. Cicero, I would say to you that you have to act on the information that's before you. Not, you're not an investigative body. You are a quasi judicial body. For example, judges don't go out and investigate. So you're a quasi judicial body and you act on the information before you as to where you think the decision ought to be. When I talked about tabling it, I think you could table if you need to review the materials that have been submitted to you. But I did not mean to suggest that you would then say, either town, you bring in the following information, it was not before you, or applicant, you bring in the following information you didn't bring today.
Right.
So I think that would be my suggestion to you as a matter of process. Thank you.
I would like to comment on that. It's just, we have a lot of information to review and to understand it, make sure that we understand it before we make a decision on it. I'd hate to make a decision based on just what I absorbed without processing it.
Yeah, and I'll speak to that. I understand that as well, but I just would like to add is, with the amount of information that was presented tonight, I just would add that the appellant has had 4 months to gather information to provide that it's a lawful non-conforming use and came with the same appeal application that they have submitted multiple times. They had a similar, for the 2008 appeal, they submitted a similar application, and same in 2016, but that was also, that same application in 2016 was also, it never went to public hearing at BZA. It was never processed fully. It's been 4 months. And the appeal, they've had 2.5 months since they filed the appeal to gather all necessary evidence. And
Mr. Chairman, I'm going to respectfully object are we arguing the case? Because if we're arguing the case,
No.
then I would like time to argue the case too.
I'm sorry.
Thought we were done with it.
Yes.
I thought we were past this point.
Thought we were done too.
Yeah, and that's all I have to say on that.
I'm with you. Any further information that someone has, I think actually needs to be, you need to go and talk to them again.
So
If they are willing to talk to you about it.
yeah, so we've already closed the.
Yeah.
And so a motion was put out to table, to follow up for a follow-on meeting.
And after further deliberation, I'll withdraw that motion.
Oh, okay.
I'll withdraw that motion. I think I'll withdraw that motion.
Okay.
So y'all want to come? What do you think?
I'd still like to review what was provided today.
So would I. So I second that.
Okay. All right.
I second that.
So, all right. So we do have a motion to table
To take,
and to review the information that we have received,
correct.
and then to come back to table it and come back at a later date.
So we got.
Okay, are we going to set a date that we're going to come back?
We don't have to vote on it.
Oh, yeah, I guess we do.
Yes, we did.
Yeah, a motion, you have to vote on.
Yeah.
Okay, so I will move forward my motion that's been seconded by Mr. Thornton.
Okay.
And we've had discussion.
So, yep, we've already had the discussion. So let's vote. Let's vote on if we're going to table this or not.
I vote that we table it.
I
Okay.
second.
A second.
Okay.
A third. I vote
Okay. So we all vote as unanimous to vote and to table this. When can we schedule a?
When do you think, how long would it take us to digest this? I think we could do it by at least the next scheduled meeting.
Right.
Yeah.
Please.
So the meeting schedule is up to you in terms of the date. It would be the next date in November. I can't remember it off the top of my head. However, it's up to you all because the BZA meets they only meet when there is an item on the agenda.
Okay.
So you're able to set that.
So I think our next meeting is scheduled. I may check my calendar here.
The 18th will be the third Thursday
Yeah, 17th. 17th.
or Wednesday.
Yeah, Wednesday, 17th. So if we could meet that day,
I'm free.
okay.
Is that good for you guys?
I'll be out of town on 17th, 2 weeks, is that?
Can your brother represent you?
Okay,
Okay.
And can he listen in? I mean,
Oh, yeah.
There you go.
there you go. Very good. Okay,
Okay. All right, this been determined.
okay.
Do we have any further?
Yeah, any further discussion or appreciate everyone's time today. So therefore, I move the meeting be adjourned.
Second. All in favor? Aye.
Adjourned at 9:04.
There you go.